Hello friends, today I'm going to speak to you about Article 12 of the Indian Constitution. Article 12 of the Constitution of India is one of the most important aspects of Part 3 of the Constitution of India because it specifies against whom are fundamental rights enforceable. At the time of the Constituent Assembly debate, Dr. B.R. Ambedkar had emphasized on the importance of Article 12 by saying that fundamental rights must be available and accessible to all the citizens. Secondly, fundamental rights must be enforceable against all state machinery. Hence, once we see that the provision has not really defined the scope of what constitutes state. At the first instance, while respecting the federal structure of the Indian nation, we see that it is the government and the parliament at the central level as well as the state level and all local authorities and local bodies. We don't see the definition of the term authorities and other authorities anywhere in the Constitution. It is only, the closest definition rather, is only in Section 3, Subclause 31 of the General Clauses Act, which includes various authorities like port trusts, municipal authorities, and state authorities or bodies which have a governmental control. With this, we now move on to the important aspects of various judicial precedents which have seen how Article 12 has expanded and what constitutes state. The definition of state in Article 12 will not only include executive and legislative organs of the Union and states, but also local bodies. This brings us to the case of Kochumi versus State of Madras, wherein the provisions of the Marammakutty Act were challenged before the court. Initially, this dispute began as a succession dispute. However, the entire process as envisaged in the local laws was successfully challenged before the Honorable Supreme Court, and it was held that even local laws like the Marammakutty Act would come within the ambit of Article 12. India has adopted the concept of parents' patrie, which means that India is a welfare state. Within the scope of a welfare nation, social justice plays a very important part because it is the state or the government that is held responsible for the economic, social well-being of every citizen of the nation. This brings us to the case of Som Prakash versus Union of India. It was held that all acts which can be brought within the fold of state action would be questionable under Article 12. This was a case where a poor man's pension was reduced when there was a takeover of the Bumrah Oil Supply Agency by Bharat Petroleum. And it was held by the Honorable Apex Court that the act of reducing a man's pension was contrary to the tenets of social justice, and therefore not only was this decision reversed by the Honorable Supreme Court, but it was held that the state is accountable for ensuring social welfare and economic welfare of an individual who has served many years in the government-run local body. The term authority was defined for the first time in Rajasthan State Electricity Board. And it was wide enough to include all bodies created by the statute on which powers are conferred to carry out governmental or quasi-governmental functions. This particular statement was used in the context of determining the scope of Rajasthan State Electricity Board. Hence, it was held that this particular board, since it has the powers to make quasi-governmental decisions, and it is dealing with the case of deputation of employees, this would fall within the ambit of authority, and therefore the term authority was determined by the Apex Court as all constitutional and statutory bodies would be considered state. This was primarily a service law matter that was brought about in Rajasthan State Electricity Board versus Mohanlal, wherein various employees had been posted on a deputation basis and they had challenged their promotion, and eventually the respondents in this matter were successful. Now, let us examine the scope of state when it comes to corporations. This is an interesting question because so far we were determining the scope of legislative actions. The first case and the most important case that we see is Ramanna Dayaram Shetty versus Airport Authority of India, because this brings about the five-pronged test to determine which cooperation would fall within the ambit of state. To determine this, it has been held that a cooperation that has significant and pervasive control by the government, or it has been significantly funded by the government, it enjoys a monopoly status protected by the government, established for the welfare of the people, or it is a private entity which has now been allowed the scope of running a cooperation by the government. Z Telefilms versus Union of India brings about an interesting case where it was held that BCCI, that is Board of Cricket Control of India, would not fall within the ambit of state, using the same analogy as held in the Ramanna Dayaram Shetty case, because the board does not constitute of a pervasive control of the government, it is not funded by the government, and per se it is not for the welfare of the people. Pradeep Kumar Biswas versus Union of India is an interesting case. Pradeep Kumar Biswas versus Indian Institute of Chemical Biology is an important and interesting case because this saw a dissenting judgment in the constitutional bench. This was with respect to whether Indian Institute of Chemical and Biology would be considered state within Article 12. A bench comprising of 5 judges held that it would be state because it is established for the welfare of the people. The initial money for the establishment of the institute, a sum of rupees 10 lakhs, was provided by the government. Therefore, it is fully funded by the government, and the government also has a pervasive role to play in it. The dissenting judgment held that it has no statutory flavor, and now the government at this particular point of time is not playing a very active role in the management. However, eventually this led to the overruling of the Savajit Tiwari judgment, and it was held that the Indian Institute of Chemical and Biology would be state within the ambit of Article 12. Is judiciary state? This question holds particular significance while maintaining separation of powers between the executive, legislature, and the judiciary. And it has always been noted how the judiciary plays an important role in maintaining the checks and balances. And at the same time, who keeps a check on the judiciary is an ongoing debate. Now, let us discuss whether judiciary would be state. The term judiciary has so far not really fallen within the ambit of Article 12. And it has been held that in the case of Deepa Hurra versus Ashok Hurra, it was held that the judiciary would fall within the ambit of state in a very limited manner, only to the extent when it's performing an administrative function and not at the time of a judicial function. Now, it is important to distinguish between judicial functions, that means a judgment being given in court, a precedent being set by court, would not be within the ambit of Article 12, especially in light of the higher judiciary, where precedents are binding on lower courts and the apex court which makes law. State of Kerala versus N.M. Thomas saw that not only is the directive principle embodied in Article 46 binding on the lawmaker as ordinarily understood, but it should equally inform and illuminate the approach of the court when it makes a decision, as the court also is state within the meaning of Article 12 and makes law even though interstellarly from the to the molecule. While determining the scope of extending the benefit of reservation to promotions, an important observation was made in the matter of State of Kerala versus N.M. Thomas, wherein it was held that the directive principle embodied under Article 46 would be binding upon judiciary while making decisions with respect to social justice. With this, I would like to conclude and summarize our lecture on Article 12 of the Constitution of India. Firstly, by taking into consideration the recommendations of the National Commission to review the working of the Constitution, which had suggested that the definition of the term authorities and other authorities be added to the letter of the law itself, that is added before Article 12, such that now all the jurisprudence that we have collected and the various precedents that we have over a period of time can be spelled out in the legislation itself, bringing about clarity regarding the scope and extent of the term authorities within Article 12. Also, we see that there has been inconsistency and a change of view with respect to whether judiciary should be within the ambit of Article 12 or not. That is why I leave the viewers with a question to ponder over with respect to the case of Naresh Sridhar Mirajkar versus State of Maharashtra, wherein Justice Hidayatullah had dissented and suggested that judiciary should be included within the ambit of Article 12. Now, let us just summarize what all constitute authority within the ambit of Article 12. As we have seen in the case of Dayaram Shetty, whenever a trading corporation has been funded by the government or the majority of the shareholders are government authorities, then it would be authority within the scope of Article 12. Furthermore, when it comes to private institutions, it is to be seen whether they are performing a job which is of public nature, and if they are funded by the government, or if they have a mandate from the government, then they would fall within the ambit of authorities. Lastly, when it comes to research institutions and educational institutions, what needs to be seen is whether they are for the welfare of the public, whether they have initial money or the capital has come from the government, whether the management, that is the trustees, or even the day-to-day functioning is done by government employees or ex officio members of the government, then all this would fall within the ambit of state under Article 12. Thank you.